All rise. Department 26, now recess, now going from Dottie. Please be seated.
Morning, thanks for waiting. We have a trial starting on Monday. Have a few things to deal with. So, we're going to start. Mr. Phillips? Mr. Phillips here? Let's see.
Is that the page 2, Your Honor?
Pardon?
Is that page 2?
Let me see.
After the first of the
Holidays
year.
coming up, yeah. So after the first of the year, maybe the Friday after the first of the year. And if it's all done and not, we'll just close it. If not, you can call you back.
Perfect.
Thanks for being here.
And also, I saw a client of mine on page 4.
Okay?
I wasn't aware that we were having a hearing today.
Virtual like this?
Yes, I don't see Mr. Roberts here. Mr. Roberts here out there.
No. So I think it was just to see if you're on track to go on May 3rd as currently scheduled.
I believe so, and there have been talks about entering into the senior deaf selling program.
Okay, all right.
So,
We'll just assume that we can leave it on for as scheduled, and we'll see you again, calendar call on May 3rd. Okay, thanks, good luck.
Thank you.
Okay, so, let me see, page 2, we've got, let's do Zorowski, do we have? Okay, great. I think we're just looking for a new date. Is this Brickhill here?
Haven't seen this Rickville. She's normally be here. This is kind of an unusual. We just got this notice. We had everything scheduled. I thought now we just got this notice. So I'm not sure what the purpose of it.
I think that this was previously set to make sure you were ready for your trial date next week, and we didn't take it off when we moved your trial. I think it's in March.
Now, it's my understanding that we have a motion for a partial summary judgment set on the 21st, and that the trial date was taken off
Exactly.
to resolve that, and then
And
we're
this
waiting.
was a pre-existing status check, and I just think we never took you off calendar. So when we moved your trial, we didn't move your status check with it. Sorry about that. That's all I can understand that it would be, because the motion is pending. So we'll see you here for the motion. Thank you for coming in, though. I apologize that we didn't catch that.
So we'll have the motion on the 21st, and then
Yes.
you'll reset the trial later on.
So set the trial date and set your pre-trial status check. Sorry about that. They go together, and this one just didn't get vacated.
No problem.
Thanks so much. Thank you for coming in. Hey, that's all. Yeah, that's all. Okay, so we've got Gilmar Roa Fierros.
Good morning, Your Honor. Travis Rich on behalf of plaintiffs.
Good morning, Your Honor. Bernadette Rigo for John Mayer.
Eric Daly for defendant, Tricia Ott.
All right, so are we arguing these motions today? If so, you're going to have to trail, or were you just here on?
Oh, we were going to argue it. We can trail it.
Okay, all right, just wanted to make sure that, because there's also a motion to amend, and I didn't know, because there's an order shortening time on this motion. I think there was a confusion about the date the arbitration hearing was going to be, and so this was set an order shortening time before your arbitration hearing, but then there was this motion to amend.
And the arbitration's already been moved, actually.
Yeah.
So if we could hear maybe all this at the...
It did kind of seem we need to know whether or not you're going to be allowed to amend before we can really roll on this.
That was our argument with counsel.
Yeah. To me, that made more sense. I mean, I understand the reason why the order shortening time was requested. It's kind of weird that the motion to amend and the motion to shorten time on this this motion for summary judgment were filed on the same day. One side asked for the shortened time because of the then currently scheduled arbitration date. The other side didn't, so they got broken up, and to me, they really need to go together. I'm sorry. So if you want to wait, you can, but you know how I feel, and you're going to have to sit through something kind of long. So it's up to you if you want to sit around and wait.
I'd rather have the argument today, Your Honor.
Okay, all right, then you can wait. Okay, thanks. Cruz versus Progressive.
Good morning, Your Honor. Clark Smith on behalf of Luis Cruz.
Counsel, hi.
Jimmy Howard on behalf of the defendant Progressive.
Is this?
It's settled, Your Honor.
Oh, okay.
And I guess the paperwork should be here in a day or two.
Okay, no problem.
Certainly before the end of next week.
Okay. All right. Unlike Judge Israel, I'm not going to sanction you. So
Great, thank you. Our sanction is having to come down here again, right?
exactly, when your case was settled. So that's enough of a sanction.
On that.
Okay, well, I appreciate that. Thanks, gentlemen. We'll see you then.
Thank you. Great, thank you.
Okay, bye-bye. Okay, Robinson, Joe Robinson Mathis and Eleanor Mathis, we have? Oh, okay, so sit up and then, okay, well, then we'll move on. So we're going to move to Stephen Paddocks, 093191. Okay, I'll take appearances of counsel.
Samuel Warren, bar number 12514, on behalf of Travis Fippen, who is the petitioner in this matter.
Tim Totolo, 3617, on behalf of 14 interested parties.
Craig Island, Your Honor, I have a PROHAC pending, Texas Bar 06502380.
Okay, thank you. You're certainly welcome to observe, but until you're being granted the right to appear, I can't.
Okay, that's Monday, so.
Okay, well, that's just a couple days short. Okay. And over here?
Thomas Grover, 12387, on behalf of Diane Hawkins, who is petitioning to be special administrator of her sister's estate, Michelle Lowe.
Good morning, Your Honor. Alice Gatton, bar number 8420, appearing on behalf of Brian Haylor, Christopher Wetzel, Robert Erdley, Charlene Walking, and Wanda Whiteman, victims of the October 1st hearing shooting with Darian Cho. Yeah.
All right. So when you originally petitioned, I think things have changed somewhat. And so where are you now with respect to your request?
With respect to our request, I think we've always wanted to have the public administrator involved in it. I know that he's filed an objection, Mr. Cahill, who is present in court today. I know that there's been people that may be willing to do it for a fee. But as far
who would that be? Because as Mr. Cahill pointed out, what you're really looking for here is a claims administrator. Mr. Cahill is excellent at his job when it comes to marshaling assets, finding out, looking for, property, including, for example, an insurance policy. But he cannot support acting as a claims manager for the potential number of claims that there are here. Somebody's got to accept service, process them, forward them to whoever. It's not fair to put that burden on the county and the taxpayers who pay Mr. Cahill's salary and staff. I can't imagine how many people he would have to add just to process the potential claims. It's too burdensome.
Your Honor, one of the things that the various plaintiffs' attorneys are discussing is that we're hoping that the court will allow a 6-week continuance on appointing anybody.
Well, in the interim, as Mr. Cahill has also pointed out, assets are sitting empty. I'm a little concerned about leaving this process on this property unguarded. As I said, we need to find out if there's an insurance policy. So, yes. we'll let the people who are involved in the pleadings. So, anything else? Does your office have anything else?
We're just concerned about the waivers.
Okay, we'll continue.
No.
No, anything else to suggest? I mean,
No, I think our biggest concern is really to marshal the assets. There are, and we know that there's 2 houses that, and I've heard that one's been broken into already. How are we going to protect those assets? Who's going to be in charge to answer to any of those? There needs to be somebody that can at least marshal the assets and protect them.
Do you need to be permanently, or could we have a special administrator?
We were just looking for a special administrator at this point, just to marshal the assets, not do anything else with the estate, just to be able to marshal the assets,
So
find out all the assets.
You would agree to limited powers, that they would not be required to accept service of process and process these claims. It's just too burdensome.
No, I think that would be fine. The main concern really when we filed this was who is going to be the face of the estate to go out together and marshal these assets to protect them for the potential claims that there are. And we know that there's possibly hundreds of them, if not more than that, right? We know of at least so many deaths and injuries, but the family members that are affected by this as well. We know that there's plenty of claims out there. We understand that even in a special, the limited powers to marshal the assets, we understand that even in a notice to creditors isn't going to be required. In fact, it can't be unless you actually grant them the general powers. And so there wouldn't be a time limit yet on those claims to be filed.
Okay. Your opposition was sort of partial opposition, and then when Mr. Barlow, I think, is no longer interested, he withdrew. But so what's remaining of the objections? Or given what Mr. Cahill said, do you see the point? And
Your Honor, at the hearing before Commissioner Yamashita, we were directed to make all plaintiffs' counsel aware of today's hearing. And in doing so, we've reached out to many of the counsel that we know who have filed suit in California, as well as the individuals who have filed suit.
I have no interest in what anybody out of state has done. I can't take into consideration anything that unless they wish to cooperate, I cannot.
Exactly, Your Honor. What we've done is there has been consolidation of some plaintiffs' attorneys who would ask the court's indulgence for a 4-week continuance. They believe that they can get all the known plaintiffs' attorneys together to handle a situation where they would address how they're going to, whether or not they're going to sue the estate and how. What we're afraid of, Your Honor, is that once a special administrator is appointed, there is going to be a barrage of lawsuits served upon them. And under the statute, since we know that there are heirs,
it's going to come off.
All of the assets of the estate will be depleted in defending these lawsuits. Furthermore, I think we're very premature right now. We have a petition before the court. However, we also had a petition that was filed by Jonathan Barlow, in which the family appointed Jonathan. So we don't even know if the family is going to appoint someone else, or if they want to.
Well, I thought they had waived their interest in their right, because if you follow the list, after public administrator is creditors, which of course these plaintiffs potentially are. We have one family that has filed creditors' claims. So we know they would be seeking the status of creditors. And the creditors are next have the opportunity. They're the ones who have the interest in seeing that this is administered. Ordinarily, it would just be gathering the assets. But the concern I have is, as you pointed out, they need some process by which they can collect these claims, and that we don't cut people off with the 90-day notice.
Your Honor, what we were proposing to do is, if we were given 4 to 6 weeks, we would reach out to the family and actually have them sign an assignment, if they are agreeable, to assign the assets of the estate to a fund which has already been established for the distribution.
Are you talking about which fund?
We're not certain which fund the
Because
plaintiffs' committee would be open to that.
But you'd ask for a constructive trust, so that's why I was trying to figure out if you'd already established a trust somewhere. So that
No, that was just to try and get some type of vehicle in place for the placement of funds. We would also ask that get on record for the court a waiver from the heirs of the shooter, Mr. Paddock, waiving and assigning any interest in the estate, and also directing the estate not to defend the lawsuits. Because I think at this juncture, whoever is appointed as special administrator basically steps into the shoes of Stephen Paddock. They have the duty and responsibility to defend him. And we feel that given the time, all of these plaintiffs' attorneys will be able to work something out, and thereby really save the assets of the estate for the victims.
How are you proposing we'll gather them? Have you looked at possibly asking Mr. Cahill if he has very limited obligations to at least marshal the assets? We've got to get the assets marshaled.
Your Honor, we were thinking that the court could appoint, say, Brian Horner, an individual simply to protect the assets. Very limited. If we appoint a special administrator, the duties of special administrators start falling into place. But if the court uses its power to simply appoint someone to protect the assets, I think we are moving forward to a situation where we can protect them for the
And who's
victims.
going to pay for that?
They would be paid for from the assets of the estate. But it would be very limited. It wouldn't be this full-blown defending the lawsuits.
I don't think the special administrator would necessarily have to unless I give him that power. I mean, if you appoint a special administrator just for the purpose of marshaling assets and for for defined purpose, why would we not have the formality of a special administrator?
Would you be able to, well, it's my understanding that once a special administrator is in place, they become the face of the estate and lawsuits can be served upon them. And once they're served upon them.
That's why I said, if you appointed a special administrator, I think don't they have to be a special administrator? How would we appoint just somebody to take jurisdiction?
Well, I don't think we would ask them to take jurisdiction. We would just employ someone to monitor the two houses. I believe the bank accounts are all in a situation where they're all frozen. Mm-hmm. We're only talking about 2 pieces of real property, one in Reno and one in Mesquite. And we could even, I believe, look into whether or not the law enforcement officials are duly monitoring them. But I think we don't want to, once the bell's rung, we can't ring it. And that's why we're just asking for this limited 4 weeks to see if we can the plaintiff's attorneys can come up with something. Mm-hmm. And I think that the only assets that would probably be at risk are the real properties. Mm-hmm. And I'm just very concerned on behalf of the victims that once we have this person appointed, someone is going to have to defend, and whether it's $1 million or $5 million, it's gone. And they're going to have nothing. Plus, I don't know if the special administrator knows exactly what they would be taking on because they are stepping into the shoes of the Stephen Paddock until such time as we get the family to waive and assign.
Mr. Grover, your client is actually has an estate for a shooting victim?
Yes, and I'll just be brief. I think right now the court has a lot of discretion in appointing a special administrator to simply marshal the assets. Under NRS 140.040, you can define the scope of that appointment, and that doesn't necessarily trigger creditor periods that would keep things running. And so, given that we have 2 pieces of real property and an unknown universe of other property, I think it's crucial that somebody be appointed right now for that sole purpose, to marshal those assets and protect them. I think Ms. Denton is correct to see if there's something we can work out, because this is such a unique situation, but I don't think that needs to be done today. So I think probably the smartest thing to do is let's go ahead and get a special administrator appointed. I would ask that the order explicitly state that the administrator does not have authority to accept or reject creditor claims.
Right,
We're
because
not starting a creditor
that's
union.
140 B, which is to, 2A. Commence, maintain, or defend actions.
Right.
So if you exclude that from the powers, which you think you can do, I think you can.
Your Honor, I just wanted to add one more thing, is that in the middle of January, plaintiffs' counsel are meeting together. And we would just request that anything be held up until after that meeting.
Okay, well, here's why I think you do need a special administrator, because the special administrator is not liable to any creditor on any claim against the estate or for any claim against the estate, the decedent, except a claim involving wrongful death, personal injury, or property damage if the estate contains no assets other than a policy of liability insurance. And don't you need to figure that out if there's a policy of insurance?
We do, Your Honor, but I don't think 4 weeks is going to change anything. And then also,
Well, but my point is, don't you need to know that? Because that changes what the special administrator would be doing. Because if there is an insurance company until they're determined to have no duty to defend, that's a duty to defend. And wouldn't the, I'm assuming, the attorney probably like to know that? I would.
they might,
Yeah.
but also, Your Honor,
Okay, well, then we'll hear from, if anybody has signed in, I think Mr. Chotolo is the only one who signed in as a plaintiff attorney, if he wishes to be heard on that.
Again, Your Honor, I'm seeing the direction the court's taking, and what we're concerned about is, as has been expressed, the waste that would occur for those assets. And again, whether Mr. Cahill can, I think we now understand that he can marshal the assets without also having to accept service of process and those types of things. I believe that would be appropriate under these circumstances. We would agree with that.
Well, it was proposed that if there are assets here, that the estate could pay someone to take that role so that it wouldn't put a burden on the public coffers. And Mr. Cahill, I think, wants to be heard on that.
Very good, thank you.
Your Honor, I noticed Sheriff Lombardo that if law enforcement releases the residences in Mesquite and Reno, that under the authority of the 253, the public administrator can protect those pending the appointment of an administrator.
I mean, because the problem is we can't necessarily assume that you can go and take possession of them now. They're, as 5 blocks away, they were still both sealed and under the investigation, so.
Yes, that's my understanding.
Are they willing to?
Well, I said when they're all done with them, if they need protection and there hasn't been an administrator appointed, I have the authority to do that prior to the appointment. One of the other complications that I thank the county attorney for pointing out, once it hits my office, it's public information. Public information requests, and I've done I think 2 in the last 2 or 3 years, are hugely time consuming and unavoidable. So I just find that's another reason why my office would be inappropriate to respond to this.
It's too much of a burden. You have to, like I said, I can't imagine the staff would be necessary to manage these claims.
No, I often in explaining how short we are will mention the fact that the Warsville Public Administrator has more full-time staff than I have and a larger budget and 1/4 the population.
Exactly.
But Ms. Donalyn Osano is here. She runs professional fiduciary services and has said she will act. That's an alternative that's right here in the courtroom. I think she's still here. And so that's another alternative. I was not successful finding any attorney to volunteer to serve as administrator. But I did want to bring up what's going on and the fact that just the public information requests would be a tremendous burden.
Okay. All right. So again, since it's your motion, there are a couple of different options. This, I think, as was mentioned, the public administrator would have the power once these assets are released. But the problem is, as I said, there are things not under police control necessarily that might be in these houses, they're just in the house, because the entire house has been sealed. And like I said, one of the first things you need to find out is there an insurance policy?
Your Honor, one of the aspects that the plaintiffs were going to look into is an agreement among all of the known plaintiffs and those who come to the forefront not to sue the estate. And if that comes into play, all of the other issues fall apart, because there will be no need for to hire defense counsel to answer lawsuits. And we just think that a 4-week continuance is not going to change too much. The public administrators did say that he does have the power, you know, if the
Houses are releasing.
right. And we just think that 4 weeks would eliminate a huge problem here. And then in 4 weeks, also, as a
Would the parties be then responsible for interviewing an appropriate, because somebody has to do this at some point in time.
Yeah.
And so the plan is they would interview appropriate fiduciaries and
Yes.
retain someone at the estate's expense to marshal the assets to the extent that that's necessary, as I understand. Turn this over to a fund so that the money's captured. It's
Yes.
not going to go away, but that it's distributed in a manner that doesn't involve the litigation.
Yes, and that the plaintiffs committee, with this goal in mind, could take applications from people who would do this pro bono. Also, there would be transparency. How much are they going to charge? Who's their attorney? How much is their attorney going to charge? Are they going to do it for pro bono? I think that if we allocate this responsibility or at least give the plaintiffs an opportunity, we could eliminate a lot of costs and actually have whatever assets there are actually go to the and as you know, we have a creditor's claim of $45 million already on file, and the plaintiffs' counsel are talking with that attorney about possibly withdrawing that, so that we have a cohesive group of plaintiffs' attorneys that are really trying to not see all this money just wasted, or if there isn't any, whatever it is, used to compensate the victims.
But again, how are we going to do that? Because one of the worries of actually appointing an administrator is that triggers the duty to send a notice to creditors, which triggers, like I said, maximum 90 days to get a claimant. And these people, some of them live in jurisdictions with 2-year statutes, some of them live in one-year jurisdictions. So I guess the problem is, how do we make sure that people who don't necessarily have an attorney participating in this process, but would otherwise be creditors, for example, Mr. Grover's client, I don't know that she's made a claim for her sister yet. So,
well, I think that they were talking about once the plaintiffs committee got something going, using a matrix from the concert, and then we'd do publication. But this is way into the future. Our plan would be first, number one, to get the family to waive the duty to defend, ask them to assign the benefits. Then we would put out a search for a person or entity that would be willing to act as trustee, see if we can find attorneys, not just Your Honor, special administrator, see if we can find attorneys to serve pro bono as the attorney for the administrator, and then come back to you and say, Your Honor, this is what we have. Get your advice and instructions on it.
and as was pointed out, because right now we don't even if we appointed somebody, they would not yet have authority to go into the house.
Right.
They're sealed. And the concern I have is, as was pointed out, I mean, there have been stories about people either attempting or actually breaking in. And, you know, that's the concern, is that to the extent there's value in these properties, that they would be maintained, and that we can, I guess, go further and marshal further assets.
Right. And the public administrator did,
So
report
if,
just for that limited purpose,
If.
without
That's what I'm
accepting. And,
so just under his statutory authority, he doesn't need to be appointed, that he could protect the assets if for some reason
right.
the sheriff would release them
And then,
until this plan is in place.
and then we believe by doing this, we would have transparency with the court. We would have transparency with all the victims. They would see the people who are possibly going to be appointed, since this is too much of a burden for the public administrator. I think this
Have you
is a
talked
win-win.
to the defendant? There is one case in which a defendant has answered. Have you talked to the defendant about their cross claims? That's another problem. I mean, if you're only talking to plaintiffs, you're only talking to half the case.
Your Honor, I personally did not talk
I
to
mean, I'll check with
Mr.
Mr. Tola and see if he's given some thought to that.
Mr.
Tola?
No, I have not received any answers.
But there is, at least in one case, the MGM has appeared, in Mr. Mills' case.
Okay.
And Mr. Weiss. There are a lot of potential cross claims if you look at the captions that have just been filed so far. So if you're talking only to plaintiffs, you're only talking to half the case.
Oh, you're right.
Again, Your Honor, I haven't received any of those, so I don't know about counterclaims. I know Mr. Piscinelli is on the defense on this. Again, what we're going to try to do to address the court's earlier concerns, we're going to try to address the judges in those cases to see if we can start some discovery to find out things like insurance and things like that. And then that would probably dictate how things progress a little bit after that. But in any event, in terms of cross claims, and again, I have not received anything. If it was filed today or whatever, I don't know. We just served complaints on MGM and Mandalay Bay, so I wasn't anticipating.
So you haven't been contacted yet by who the defense counsel might be?
I have not.
Yeah. But that is my concern, is we keep talking about the plaintiffs and how you're going to make this all over for the plaintiffs. But you've got defendants who
Right.
have cross claims. So if you're only talking to plaintiffs, you're only talking to half the case. And that's a concern for me.
We would reach out to them also, Your Honor.
I don't want to be one that's being the bearer of not worrying about the people that he victimized with his actions. But as far as the estate's concerned, what about other claims that may need to be protected against? Has he paid his taxes? Does the IRS have some major claim in there? That's something that needs to be found out so that we know exactly what's even going to be available for everybody.
Yeah. So, but our fear is if we do it now, we trigger a very short period of time.
But with the special administration, you have to give the special administrator the ability to file that, the authority to actually file a notice to creditors under a special administration.
Right.
So really, the idea would be just to find out what there is so that we can start this process, and then when
As I
everything is figured
understand,
out.
and I don't want to speak for Ms. Denton, but as I understand her concern, even if we have a special administrator now, there are certain obligations, and somebody may not want to participate in this proposed agreement, may file their lawsuit and expect an answer because, I think I could probably tailor an order that would say you don't have any authority and you're obligated to accept service or defend any lawsuits. That would be great. The problem is that Mr. Peel has pointed out, you're not going to be able to get into these properties yet. So can we allow some time to see if somebody can come up with a proposed person to serve as, I would agree with you, special administrator initially. I am, as you are, really worried about the people who might be cut off by our very short creditors period. And so if we could get started on this with a proposal for how we're going to, you've got to have somebody accepting service and managing these claims, and that's going to be a huge and complex task. It's tens of thousands of claims, potentially. It's going to be a full-time job for somebody, probably. So that's kind of our point. If we can get this set up front, we have the fallback that if for some reason all of a sudden the police say, we're letting go of this property, we're not going to consider it sealed anymore, come and get it. Statutorily, he could be the one to go in and secure the property and at least maintain that real estate, hopefully for us, until we can do exactly what you said. We have to get ready and do this in an appropriate fashion so that we can make it, just like you said, what if there is a gigantic tax lien that wipes the whole thing out? We don't know. And we have no way of knowing until we get somebody in place.
Mm-hmm.
So there's a proposal. As I said, I was concerned when they said they were only talking to other plaintiffs. The plaintiffs are only half the story, sadly. there are cross claims among these potential defendants that you have to take into consideration as well. So if that's the proposal, then I agree. We need, as you point out, we need someone eventually, we need a time frame to get somebody in place, because that's one thing we've got to figure out. Are we going to be up against some stumbling blocks that we've not yet on notice of? So I think that you make a good point, but what would you consider to be an appropriate amount of time? Because that is ultimately, it's still a mistake, and we have to treat it as such. So keeping in mind the concerns that have been raised so far, do you see a problem with, I think Ms. Denton said initially 4 weeks, but with the holidays coming into play, I mean, do we need 6 weeks to have our follow-up?
That would be
Yes.
best.
I think that would probably be okay, as long as we can make sure that if the houses are unsealed in that interim, that Mr. Cahill will be able to at least marshal those. And I know that I'm sure that there's frozen bank accounts, and that the police have already taken care of on that side, but there may be assets that are unknown and that they haven't found yet, so.
Yeah. Okay, I think that's a good idea. However, as I said, I would only agree if we actually do, because I know that it's easy to think about this just as involving the victims, but the litigation doesn't just involve the victims. So you have to be sure that there's no defendant out there who's not going to agree and is going to try to bring the estate in. Otherwise it won't work. So is that agreeable? If we set the hearing in 6 weeks, would you then have time to get your proposal in place? And again, if you need to continue, certainly we would understand, and we could move it again. But I have to agree with counsel. At some point, I appreciate the problem. Once we start down this road, it's a very short time frame. It's maximum 90 days. And there are people who aren't even thinking yet about filing because they're still treating. So at some point, we've got to do that.
That's exactly our worry, is that there are people who are in comas. We have people who do not know the full extent of their trauma, and we have people who probably will not even know whether or not they're traumatized for 6 months, 9 months, 12 months, and this 90-day notice to creditors is going to bar them. So if we can try and do something to assist all victims, I think.
And where we can, as counsel pointed out, get maybe just a special administrator at first in place so they can tell us what we're dealing with, then it's time to turn it over to an actual administrator and start the estate process. We're going to have to do it. Our statutes require that 18 months is a goal, but it's not always possible to meet. But we try to move these things along for all creditors. And as he's pointed out, we don't know if there are other creditors who would have claims. So we need to at some point get this all worked out. But I think it's a good suggestion to come have the parties to the litigation, not to the estate, but to the litigation. I don't know anything about it, but as I told you, I really can only deal with people who, for example, Mr. Grover's client, who is a claimant with a probate case, or the people with the creditor's claims. I wanted all the plaintiffs here because I felt they needed to understand that their civil litigation has a whole different track than a probate does. So we needed to make sure everybody understood that and was working together. So as I said, as long as we can involve, at least if we know of any defendants, like I said, I only know of the one that's answered in the one case. So maybe they get to speak for all the defendants, but I think you do have to involve them. So if we go 4 weeks out for your report and then 6 weeks out for the next hearing, that works.
Okay, the report will be due January 11th.
Can we go to the last week of January? It's off this next year. So the hearing's the last week of January, we have 2 weeks before that.
Right, that's what I'm going. The last Thursday in January is January 25th.
Is that going to be enough time?
I don't think, Your Honor.
Close after. Do you want to go all the way? I hate doing it. Do you want to go all the way to the end of the month? Okay, so then we'll. Okay, the report will do at the end of the month. I don't like stretching it out that far, but because my concern is, as Mr. Hale has pointed out, the police have no obligation to follow our timeline. And if they, so I don't know, Mr. Hale, if you or your council are comfortable with that we're not appointing you, we're not giving you any obligations, but since we can't control the police, if they in the interim should release the houses, can you secure them at least until such time as we have people in place, because it's not going to be until the middle of February, probably. Is that a concern for you?
I think that's not a concern, except that when we say we secure a resident, we don't do it the same way the police does.
Right.
I mean, we photograph, remove any personal property that somebody might want to haul off, like a souvenir hunter or something like that.
Exactly.
But I don't have anybody outside the residence.
No, it's understood.
Yeah, okay.
It's understood. They are so different from what we do in probate or civil cases. But that would be my only concern about going that far out, is when the police determine their investigation's done, they could just make the announcement. And Mr. Hale's right. That's the concern, is that once the public potentially has access, it's a problem for us. So if everybody's comfortable in going out that far, because it'll end up being 2 months, then we can't require Mr. Cahill to do anything other than he does under his statutory duties. Is that agreeable? Okay. As long as that's agreeable, then we'll move it into February, so we'll give you the dates.
So the report will be due the last day in January, which is the 31st. The hearing would be February 15th, 10 a.m.
So what are you doing otherwise to notice people in the interim? Is there some agreement or plan? Because I know that this is their petition originally, and they may have some concerns from their viewpoint.
We'd be glad. We've reached out to the attorneys that we know of. We've also reached out to California, Chicago attorneys. For some reason, we just were not getting very much cooperation from them. But I think that we're pretty much on the same.
And the problem
we are.
that
Yes,
the problem
we
we
are.
have is Mr. Grover's issue, which is his client is working first on her sister's estate, and she may ultimately file a lawsuit, but we've also need to capture the people and I don't know who they are. And again, we would only have control over it, and there are only 8 in Nevada. So I don't know how many wrongful death cases might be coming from people who simply opened their local estate.
Well, we represent 2. So,
And well, then you've got Mr. Grover. So.
And we've instructed them to go ahead in their jurisdictions and get special administrators appointed, and that they would have to do that to pursue any type of claims.
So just, again, if there's they may not yet have filed a lawsuit or been planning one, they're dealing first just with a loved one who's passed away. So I don't know who that universe is, but it's small, thankfully, compared to the tens of thousands of other kinds of claims. So, okay. We have a plan. Thank you very much.
Thank you. Just to clarify for me, the report is about our plan of what's going to happen, how we're going to proceed with this. Right?
You need to work with, and that's why I said about how many probate attorneys we have that are on a different track that need to be reached out to and understand what is being proposed by the personal injury part. And it's not just plaintiffs, it's about cross claims.
Okay.
I don't think, with all due respect, we're considered.
So we'll work together.
Thank you, Joe.
Okay.
Everybody's working together.
Yes, no, I'm happy, I'm fine to do that.
I appreciate everybody coming in. So I guess the issues, I think their concern is, since this is their petition, they have no obligation to do the notices or to do any of the outreach, but we'll include them in discussions. I think that's probably the concern, because they were doing just the probate issue. And that's why I'm saying there's the probate, there's the plaintiffs, and there's the defendants. So good luck, and if we need any kind of further notices or service, you're prepared to do that. And so this burden's off them, because it's technically their petition, and I'm sure they're like, we didn't know about this, and we didn't apply for this, and we don't know how to notice these people. So
That is one of our
concerns. Yeah, okay. So that's agreeable, then thank you. Okay, we'll see you guys in a couple of months.
All right.
Appreciate everybody being
Thank you
here.
very much, Sharon.
Your Honor, if I could beg the court's indulgence.
Yes. You're our last witness.
Oh, I was supposed to be at Jim Jimerson's office on the Supreme Court settlement conference about a half an hour
No
ago.
problem.
And I would really appreciate
I
it.
think you already read our last issue, so Mathis. You took the, yeah. So this is our last probate case, so it's page 5 of the probate calendar, Joe Robinson Mathis, and Eleanor Rodriguez.
Morning, Your Honor. Ross Evans, bar number 11374, on behalf of James Mathis, beneficiary.
And James Adams on behalf of the trust.
Printed the